Okay, everyone, we're going to kick it off. Thoughtful that it is Friday at 3:30 Eastern, so certainly you may be heading somewhere else after this. A really warm welcome to all of you. Thank you so much for being here with us today and for making it to this concluding day of the ASIL annual meeting in person and hybrid. Really phenomenal to be here in person. Today's topic, to make sure you're in the right room, is Transnational Discovery of Evidence. Is there a best practice? As we explore the topic with our noted speakers, consider whether there will be a comprehensive solution to the cross-border gathering of e-documents and regulations. How can we best co-develop enduring, important protocols? Because we may posit to you that they don't necessarily exist already or comprehensively in the space as the space is evolving in real time. It is my great pleasure to introduce to you today, in the order that they will make their presentations. First, Professor Vivian Curran. Professor Curran is the Distinguished Professor of Law at the University of Pittsburgh. She is a celebrated and distinguished friend of the Republic of Austria as a U.S. appointee to the Austrian General Settlement Fund Committee for Nazi-era property compensation, and of the government of France for her work promoting French language and culture in the U.S. She will offer the foundational framework from which we will begin our conversation. After her presentation, we then turn to Megan Crowley. Megan is a litigation partner in the D.C. office of Covington and Burling. She is a high-stakes trial lawyer representing leading tech companies with focused representation on cybersecurity and data privacy. For you TikTokers out there, Megan was a key member of the team representing TikTok to defend the app. Do ask her about it after the session. I have to, of course, also offer my thanks to the ASIL team and community, and in particular Wes Rist, for all of the help to make sessions like this possible. I would be remiss as well if I didn't share my co-chair is unable to be here today, Carrie Xu Sheng. Carrie is an assistant professor of business law and an arbitration specialist at the College of Business Administration at Cal Poly Pomona. And I wanted to celebrate, we have an incoming co-chair who will take my place going forward, Professor Jeannie Huang. Jeannie is the incoming co-chair of this section, the PILIG. She is associate professor at the University of Sydney Law School, specializing in conflict of laws and digital trade e-commerce regulations. If you are already a member of the PILIG distribution list, stay tuned, of course, for more details and forthcoming commentaries that we'll be introducing. Without further ado, I'd like to turn over the microphone, please, to Professor Curran.
Thank you very much. It's a pleasure to be here. I also want to thank Reka and Carrie and ASIL, and to note that the wonderful Wes Rist used to be at the University of Pittsburgh Law School before ASIL stole him away from us. And I know he's been doing a stellar job here. So I wanted to start out by mentioning that, as probably many of you know, the process of globalization has been transnationalizing law for decades. Some of you may have read the op-ed in the New York Times this morning, which assures us that the era of globalization is now over, by David Brooks, but notwithstanding that, law has been transnationalizing as a result of it for a long time. And a new dimension to discovery issues has been raised by it in transnational cases. So judges are finding themselves dealing with foreign blocking statutes in transnational cases. And those are statutes of foreign countries that forbid their nationals from disclosing certain kinds of information, often economic in nature. Today, these judges have to deal increasingly with information, with data that is without location, that's locationless. So blocking statutes mean that U.S. judges have to balance the rights of the U.S. party to information under discovery rules that are considered by many to be a constitutional right in the United States, or at least a quasi-constitutional right, against the general principle of refraining from requiring foreign parties to violate their state law. The difficulty of digital data cases is how to apply existing legal criteria that were developed over centuries on the basis that national law is territorial to cases which epitomize the deterritorialization that the internet creates wherever it reaches. Under common law stare decisis, courts are bound by well-established laws of jurisdiction that are intertwined with discovery and blocking statute analysis, and that all have as their point of departure two basic principles. First, that a court's jurisdiction is bounded by geographical territory, and second, that in international law, each nation's legal rights are limited to its national territory. And superimposed on this is the United States' presumption against the extraterritorial application of its national law. This presumption, on the one hand, is part and parcel also of international law. On the other hand, it is also part of a growing trend on the Supreme Court towards greater respect for international comity. At the same time that the U.S. Supreme Court was adjudicating the Microsoft case in 2018 that dealt with digital data, two other events were occurring. The Cloud Act was enacted, which facilitated U.S. law enforcement's reach into foreign states for digitally stored data. And also in 2018, in the European Union, there was the passage of the GDPR, the General Data Protection Regulation, a regulation that imposes stiff penalties for violations of the privacy of EU citizens, and that is focused very much on the rights of each and every EU citizen. Let me just mention with respect to the Microsoft case that in the initial appeal, the Second Circuit had held that the law at issue did not have extraterritorial effect. And the court did so by analyzing recent case law, which embodied the increasingly strong presumption against extraterritoriality that we have in the United States today. The Second Circuit's concurring opinion was in fact the only one to address the novel issues which the majority had not discussed. The Second Circuit concurring opinion said, "What searches are unreasonable is a difficult question when courts are assessing statutory authorizations of novel types of searches to deal with novel types of threats." And that same concurring opinion sized up the problem as being not primarily one of privacy, but as the, quote, tricky issue in a world of transnational transactions taking place in multiple jurisdictions at once, of deciding whether a proposed application of a statute is domestic or if it is extraterritorial. The majority in Microsoft had relied in part on the Restatement Third of Foreign Relations, but the restatement's analysis was itself derived from the traditional concept that the information would be tangible. Judge Lynch, who authored the concurring opinion in Microsoft, articulated the dilemma in applying a law of physically embodied information this way. He wrote, "Electronic documents are different. Their location on a computer server in a foreign country is in important ways merely virtual. The very idea of online data being located in a physical quote-unquote place is becoming rapidly outdated because computer files can be fragmented and dispersed across many servers. Corporate employees in the United States can review these records when responding to the warrant or subpoena or court order just as they can do in the ordinary course of business without ever leaving their desks in the United States. So as I mentioned, in the same year that the Cloud Act was enacted and the Microsoft decision mooted, the Microsoft decision in the Supreme Court, the European Union passed the GDPR, its General Data Protection Regulation, to regulate data protection in a way that ensures the privacy of its EU citizens. The fact that the GDPR's focus is so overwhelmingly concentrated on the rights of its citizenry to privacy makes its reach immeasurably vast. It encompasses any company which does business with a citizen of any EU member state and anyone who either processes or controls data, and it insists on EU citizens' need to consent to having their data collected and on their right to withdraw such consent at any time. The discovery law we have in the United States that applies the GDPR, which is a blocking statute, has shown U.S. courts reasoning under the legal standards set in place for determining whether to allow discovery under the rules of civil procedure. The bottom line is that it isn't really possible for judges to do an effective job of deciding this without understanding relevant foreign laws, the relevant blocking statutes, and undertaking comparative legal analysis. But U.S. courts, generally speaking, are not equipped to do this. The U.S. court's principal way of dealing with foreign law is by avoiding it as best they can. One such foreign law has been and continues to be the Hague Evidence Convention. The Hague Convention was negotiated and ratified by the United States, and it was intended to facilitate the taking of evidence located abroad. Since the United States Supreme Court decision in the Société Nationale case in the 1980s, the Hague Evidence Treaty has been only a potential alternative means rather than the exclusive or even the favored means for obtaining evidence in transnational cases. And the predominant method of getting discovery evidence has been through the federal rules of civil procedure ever since that decision was decided. By applying the federal rules, U.S. judges have been able to prolong their unfamiliarity with the workings of the treaty as they continue to apply the federal rules which they know well and with which they are comfortable. Given that the Hague Evidence Convention does not provide for the broad discovery considered fundamental to parties' rights in the U.S. legal system, rights which many U.S. judges evoke, the Hague Convention seems the less preferable choice to U.S. judges. But to European signatories, the Hague Convention is the exclusive means they recognize as legitimate once a state has become a signatory. And so they consider the United States' ratification of the treaty to signify the United States having undertaken the obligation to use the Hague Convention as the exclusive means of obtaining evidence in transnational cases. In general, U.S. courts both do not use the Hague Evidence Convention and are not finding the GDPR to be a reason to bar discovery requests. In a number of GDPR discovery cases, the U.S. courts are holding that the foreign party has failed to establish that disclosing the requested information would in fact violate the GDPR, even in cases where a plain reading of the statute of the GDPR would seem to suggest otherwise. In other cases, the courts are holding that the foreign party is unable to show that the GDPR would in fact be enforced. And enforcement of the blocking statute in the home country of the party claiming the blocking statute as a reason not to comply with the U.S. discovery request has always been an important criterion in blocking statute analysis for U.S. judges. Since the GDPR is still fairly new, there generally has not been any history available to parties of the entities being subjected to the regulation's penalties for complying with U.S. discovery. So it remains to be seen what U.S. courts will do if these penalties are in fact imposed. The penalties contemplated in the statute are significant. At least one important French legal scholar is baffled by the U.S. court's general failure to respect its terms in discovery cases for that reason. Another scholar, this one from Germany, has suggested that to date, the GDPR's weakness has in fact been a failure to be enforced. So the ubiquity of the GDPR's reach, combined with the severity of its penalties, may cause U.S. courts to proceed with more caution than they have been in the few years since the regulation was adopted. If the EU in fact enforces the GDPR's provisions for violators which comply with U.S. discovery orders, and also I think if the importance of privacy in the EU can be successfully analogized in U.S. discovery cases to that of privacy law in precedents interpreting Swiss bank privacy laws, because those blocking statutes are recognized and respected by U.S. courts in discovery cases. So the French blocking statute is generally not recognized as a serious blocking statute, and the reason that's been given is that it has not been enforced, which is more or less true. There are some examples given, oh yes, it was enforced in such and such a case, but really, it really hasn't been. I think the analogy is in order, let's say with the Swiss banking statute, at least the analysis of the blocking statute in order to have the GDPR recognized as a reason to enforce the GDPR in discovery cases. It would take me beyond the time allotted here to explain why. So I'll end here, but the roots have to do with how the EU's concept of privacy developed over time. And so if anyone has a particular interest in that, maybe that would be a subject for the Q&A period. So I will end my presentation here. Thank you.
Thank you so much, Vivian. That was a phenomenal sort of foundational framework on how GDPR and blocking statutes came into play. We're going to stick with discussing even more so about privacy with Megan. We're going to look to privacy, we're going to look to discovery, we're going to look to privilege for privacy in the context, for example, of China, but then also sort of best practices and how do we buttress those. So without further ado, Megan, if you would please take the floor.
Yeah, thank you. Thank you all very much for being here. Thrilled to speak with you all today about this very interesting topic and rapidly evolving area. So what I want to talk about today, I'm kind of dividing into two buckets. One, like, what is the problem, which Vivian already started to lay the foundation for us. And then to pivot to best practices. What do we do with this problem? So looking first at what how we articulate what the problem is, the most basic part of the issue is differing notions of privacy across the globe. So foreign privacy and data protection laws impose restrictions on the collection, review, and dissemination of various forms of personal information. And personal information and data is defined very broadly in these statutes, and including as much as individual email addresses under the GDPR and a number of other privacy statutes, which is, of course, one of the most voluminous forms of e-discovery. It is basically impossible to collect e-discovery without getting email addresses. The number of data localization measures has roughly doubled in the past 5 years, including in at least 62 countries with 144 restrictions. And these localization efforts can result from either explicit legal rules prohibiting the transfer of this information or de facto rules that make it so impossible, so costly or time intensive or technologically impossible to do those transfers. So we heard from Vivian about the GDPR, which is, of course, the most well-known example of one of these statutes that prohibit the transfer of personal data. China is also a notable example. China has, in recent years, enacted a number of statutes that prohibit the transfer of Chinese data outside of China without the explicit consent of the Chinese government. So the China Data Security Law and the Personal Information Protection Law are creating significant difficulties for parties involved in litigation in the US courts and in other jurisdictions who are seeking discovery materials that are stored in China. As I said, both the DSL and the PIPL, these statutes require data processors to obtain approval from the Chinese government before transferring any data stored in China to a foreign court or law enforcement authority. And the fines, just as under the GDPR, are significant, up to 5% of a company's revenue and potentially millions and millions of dollars. Even looking more granular at individual countries, for example, in the United States, there is a patchwork of data security laws at the state level, which create another level of complexity. For example, California and Virginia have privacy statutes. 20 additional states introduced legislation last year for additional data security legislation, and that patchwork of treatment of data security issues creates another hurdle to overcome in the context of e-discovery. So putting aside the differing notions of privacy, or putting a pin in that for the moment, there's also the level of the differing notions of discovery. So of course, as Vivian briefly addressed, in US federal courts, discovery is much broader in scope than in other jurisdictions, and is primarily conducted by the parties with less involvement by the court. Civil law countries, by contrast, generally allow little or no pretrial discovery. Additionally, most civil law jurisdictions require heightened specificity in their discovery requests that are allowed, whereas in the United States, discovery requests can be exceedingly broad. So the distinctions in the language, even, of how to make these requests create additional complexities and reflect these differing notions of what appropriate discovery should be. There also is, in different jurisdictions, of course, differing notions of privilege. So for one example, in the United States federal system, confidential attorney-client communications are privileged and protected from discovery. This is equally true of an in-house attorney who works at a corporation, for example, and who is employed by the business. In the EU, by contrast, privilege rules require the attorney to be independent. So that removes any privilege from communications from in-house lawyers. So those additional levels of divergence between the US system and other systems regarding what would be acceptable production of a privileged material, again, an additional layer of complexity. Of course, another complicating factor is the volume of electronic discovery. So businesses and individuals, but particularly businesses, create a staggering amount of discovery of electronic data, including emails, presentations, accounting records, reports, spreadsheets. This is just an enormous amount of data. And so responding to e-discovery requests accurately and completely can be extremely time-consuming and require substantial resources. There also is a complexity added by the technological overlay. So the complexities of cross-border e-discovery, particularly when it implicates cloud computing, are enormous and evolving rapidly. So data that can be accessed in one jurisdiction may be housed on servers in another jurisdiction, and therefore subject to another jurisdiction's data protection laws. So increasingly, an enormous amount of data is subject to concurrent jurisdictions, which could be conflicting as to what the appropriate treatment of that data is. Different data protection regimes, different discovery obligations, different privilege law that's applicable. Even preservation of documents can trigger certain data privacy issues, such as under the GDPR. So even just sending out a litigation hold in a litigation can trigger some of those privacy obligations. And different rules can apply in the civil context and in the criminal context as well, and in the gray area of civil enforcement proceedings. So whether one country treats a litigation against the United States Securities and Exchange Commission as a purely civil matter or a purely criminal matter may be viewed differently than it might be by someone who practices in U.S. courts. So I think that given these number of different factors, there's a lot of complexity, and the stakes are incredibly high. There are potentially enormous fines for violating foreign data protection laws. Similarly, in the United States, violating the Stored Communications Act can result in criminal or civil liability. Even putting aside those pieces of legislation, courts who are adjudicating these disputes may bar or limit the use of electronic discovery that has been obtained unlawfully. On the other side of the ledger, courts also may impose sanctions if you fail to comply with your discovery obligations. And as Vivian mentioned, U.S. courts have been less willing to recognize the difficulties of complying with data protection laws in other jurisdictions and generally take the view that the obligations of the parties under the federal rules of civil procedure in the United States trump foreign law. That has been the overall trend of the cases. In some jurisdictions, again, notably China, there are also potential criminal sanctions that can be imposed for complying with foreign discovery obligations. So in China, you cannot sit for a deposition for use in a foreign proceeding. And the consequences of doing so can be quite high. So if you are litigating a dispute in which a witness is in China, that individual will need to leave mainland China to sit for the deposition. And again, this evolving regime in China of how to deal with privacy and data protection in general is rapidly evolving, and the contours of that system are far from well defined. So the resulting situation is that conflicts are frequent in U.S. courts and in other jurisdictions between data protection laws. And as I mentioned, and Vivian mentioned, U.S. courts have largely concluded that foreign restrictions on taking discovery, such as the Hague Convention and data privacy laws, do not displace the federal rules of civil procedure. So, problem framed. What do we do? I think, including in the Q&A, it would be very interesting to hear about how we are to discuss further what the best practices look like. I'm a litigator, and from my litigation practice, there are certain practices that have been effective in addressing this problem. But as I said, it is a complicated problem that is constantly evolving and requires careful thought in each specific case. So first best practice is to educate yourself. And so everybody who's here is already doing their first best practice of educating yourself about what the problem is. And so what I mean by educating yourself, though, in more detail, is that you should identify possible problems early in any dispute by conducting an early case assessment that addresses cross-border data collection and production issues. So, for example, where are your custodians located? Where do they reside? Where is the data located? Where are the servers located? Where is the data stored and backed up? Are those in multiple different places? Drilling down on those fact questions early will save you significant headaches down the line. Once you've identified what jurisdictions are at play, of course, you need to look into what the applicable foreign data protection laws are, what blocking statutes might apply, and other industry-specific laws as well. So one thing neither of us have mentioned is that some jurisdictions also have specific laws that apply to, for example, the banking industry or healthcare. And so it's very important to, in addition to the broader jurisdictional laws, to look more deeply at the industry-specific ones. So another way to educate yourself about the case, of course, is to engage, assuming we're talking working with a corporation, engage with in-house counsel to understand the corporation. So educating yourself on how the corporation is structured, its operations, how the parent, subsidiary, and related companies interact is very important to determine whether the data is in the possession, custody, or control of the relevant entity which you're representing or seeking discovery from. It's also important to educate the relevant attorneys at a company regarding the obligations, red flags, decision points that are relevant to this discussion. So, for example, I mentioned a litigation hold, a legal hold telling folks at the company not to destroy data while the litigation is pending should be broad enough to comply with the obligations under the jurisdiction you're litigating in, but also limited to with respect to the number of custodians or the data categories, the relevant time frame. There's a danger in a couple different dimensions, but specifically as we're discussing here, there's a danger in having too broad of a litigation hold that just captures everything, because then you're going to sweep up a lot of information that might be subject to a data protection law in a foreign jurisdiction that is not necessary to fulfill your obligations under in a U.S. court. So talking with in-house counsel about how to navigate that is essential. Also, at the end of a matter, remembering to destroy or return data at the end of a matter and to lift a legal hold. Again, the idea of data minimization, not collecting or keeping more than you need to, is centrally important. So after you've educated yourself, next step, engage with opposing counsel. So this engagement primarily takes two forms. First is a cross-border discovery protocol. And most of those discovery protocols tend to have phased discovery. So the party and what I mean by that is the parties would agree to review, for example, if you're litigating in a U.S. court, U.S. production, U.S. documents first. And then afterwards to reconnect with opposing counsel, have another meet and confer, to agree about the scope of additional foreign discovery. And in many cases, the parties can agree that it's not necessary, that whatever is available in the United States is sufficient to fulfill the parties' obligations under the discovery requirements. Or if not eliminate it entirely, perhaps agree that non-U.S. custodians' collection from those folks can be limited. In that cross-border discovery protocol, it's also very important to build in additional time for cross-border requests, knowing that it always takes more time when you're dealing with cross-border issues. Similarly, limiting the number of countries that you will collect from or the scope of the foreign collection. And if protected data must be produced, there are ways to create in this discovery protocol safeguards to limit the production, such as producing the data in a redacted or anonymized form. That can build an additional level of protection for the data that would minimize your risk of running afoul of the foreign data protection laws. Other than the discovery protocol, the other main thing to do with opposing counsel is to negotiate a confidentiality agreement. The agreement can, for example, limit the number of people allowed to view the protected data and impose immediate destruction requirements on protected data. So, of course, an attorney's eyes only designation can limit the number, limits the number of people who can look at the data and therefore limits the exposure that you have under foreign data protection laws. Similarly, this confidentiality agreement or the discovery protocol can include information security provisions. So when you turn this data over to your adversary, how are they protecting that data to make sure it is not exposed? And it's always a good idea to consider having the agreement and protocol memorialized in a court order to give an additional stamp of, of approval. So that, of course, requires engagement with the court. And so that's the next step, is making sure that early in the litigation you educate the court to the issues at play and the cross-border issues at play. And that can include providing the court with an affidavit from a foreign law expert who can opine on the requirements that this data is subject to, and which might both slow down your ability to collect this information and in some cases prohibit it, because you want to preview early that this is a hurdle, and that this is not you being a difficult litigant. This is a hurdle that is just the reality of the world we are in, and that it can create difficulties that will frustrate the judge. But educating the judge early is a really good way to minimize the ire that is directed at you. So in thinking through how to implement your discovery plan, there are certain workarounds that creative, and I'm sure there are many more that are not on my list, but of creative ways to get around these limitations. One, for example, is conducting a responsiveness review and privilege review abroad. So that would mean that you would only be exporting to the United States a smaller universe of documents than the full collection. And just by data minimization in that way, you can expose your risk. Similarly, considering whether home country, so if you're litigating in the US, whether US-based custodians can provide identical or similar documents, or whether the documents are hosted in the United States or the jurisdiction in which you're litigating. And again, so that would just, simply by asking the question of your client, you could potentially obviate the need to engage in cross-border discovery by realizing that the documents are already in country, or that there's someone in country who can already speak to the issue that you need them to speak to, or who already has similar documents. And then the other potential workaround is using technology and AI to potentially filter out personal information. So, there's plenty of software that can quickly scan ESI and determine whether, what emails are in there, and be able to kind of quickly identify the subset of data that potentially doesn't have any PII, or is able to be dealt with in a more straightforward manner. And the final way to make sure that you are creatively thinking about this problem is to engage the experts. And what I mean by that is practitioners who regularly deal with privacy issues, who regularly deal with cross-border issues, outside e-discovery counsel, and technology vendors to consider alternative ways to address these problems. You're not the first, if you're facing this problem, you are certainly not the first person to be dealing with this problem, and you will not be the last, and the technology is constantly evolving. So I'm frequently surprised that my information of 8, 9, 10 months ago is outdated. And so that goes for both the regulations that you were subject to, the laws you were subject to, and also the potential workarounds that have been identified and created. I think at this point it might make sense to turn to the Q&A. We're happy to talk about any of these issues in greater depth, but we welcome your questions.
I'm going to pose a few questions and then open it to the floor. So please think about the questions that you want to ask if you do, and we'll get to them in a moment. So pulling from the delegates online or in this room as well, there's a question on 1782. So we appreciate there's a circuit split when we talk about Section 1782, but I pose it generally to both of you. The question is, what is the impact of Section 1782 on foreign companies in the United States? Well, Megan's smiling at me with a big, I'm going to give it to Megan first and then to Vivian, if that's okay in that order.
Yeah, that sounds great. So Section 1782 it's a U.S. statute, and it makes discovery rules, essentially what it does is it makes the U.S. discovery rules available to foreign litigants whose domestic legal systems are often stricter or do not even contemplate pretrial discovery. So what the procedure under the statute is, it allows a party to file a request with the federal district court in which a discovery target is located in the United States, and that for use in a foreign proceeding. And the use of this procedure has exploded in recent years. And often the request for discovery is ex parte, meaning that the parties might not be, the parties in the foreign proceeding might not even know that this discovery request has been made. The foreign tribunal might not know that this is happening. It will be a U.S. court who is deciding whether to provide access to discovery in its jurisdiction for use in the foreign proceeding. There's a very high grant rate of these requests. There's a very low contestation rate, in large part because they're often ex parte. And as I said, it is just exploded. And so what? There's actually not that much case law on the use of this procedure in recent years, and often they're granted with minimal judicial activity, in part again because of the ex parte nature of the requests. So the key takeaway of the use of 1782 is that it's an incredibly powerful tool for foreign parties seeking discovery that is under the possession, custody, or control of a U.S.-based entity, and really makes it such that foreign parties that have limited discovery regimes in the jurisdiction in which they're litigating can go to a U.S. court and get the benefit of the very broad U.S. discovery rules. And so I think it really does create an imbalance often, and given, we touched on cloud computing, given the use of this tool combined with data that is stored in the U.S. or under the possession, custody, or control of a U.S. entity means that all of that data arguably could be discoverable even if the jurisdiction in which you're litigating has very limited discovery rules. So it's a fascinating area. If you're litigating this area, you should definitely check and see whether this is a tool that you can use.
Yeah. So I'll just add a bit to that. So 1782 was meant to be a service on the part of U.S. courts with respect to proceedings in a foreign tribunal. So the 1782 proceeding will be with respect to a matter that is being litigated by often two foreign parties in a foreign tribunal. And as Megan said, this will give one private party the right to request the production of documents over which a U.S. judge has jurisdiction. And generally speaking, when I have had contact with practicing lawyers in the United States, about 100% of them will say this is just a fantastic opportunity. It's a wonderful thing, and it does such good. Well, this is not the opinion of Europeans, where 1782 is viewed as highly inequitable. So 1782 allows, and U.S. case law has made it clear that it allows discovery of information that is not discoverable in front of the tribunal before which the actual case is being tried, before which the foreign proceeding is occurring. And it allows the parties seeking the information, and as you just heard, 1782 petitions are liberally granted by U.S. judges, access to enormous amounts of information, which the other foreign party in front of the foreign tribunal, which does not permit discovery, has no similar access. So it is, in that sense, I would agree very much with what you say, highly imbalanced.
Just to get a sense of the audience, please raise your hand if you've been involved in a Section 1782 petition. Yeah, many of us have read about it, but actually being involved with it, it's interesting to parry with that. Vivian, I'm going to go to you for the next question. if you could share your insight on the impact, effect, and even implications of the US-EU transatlantic data privacy framework, and aligned with that question, a question from a delegate, is there a need for another or an international treaty regarding data protection and regulation?
So what happened was that in 2020, the European Court of Justice, or as it's now called, the Court of Justice of the EU, decided in a case known as Schrems II that the previous EU-US agreement, the Privacy Shield, was not adequate, so that it violated EU privacy requirements. And so now the United States and the European Commission have committed to a new transatlantic data privacy framework. And so the idea is that there are new safeguards so that signals intelligence activities on the part of the U.S. Will not violate the privacy of EU personal data. And there is a mechanism in it for EU citizens to seek redress if they feel that their data has been compromised. And so I think, so both sides have absolutely an interest in such an agreement. More than $1 trillion in commerce crosses the borders each year, so both sides would like to have something that works. So the new agreement is supposed to address the Schrems II decision, and among the things that it does is requires the signals intelligence collection to be undertaken only if it's necessary to advance legitimate national security objectives. It cannot disproportionately impact the protection of individual privacy or individual liberties. And the other thing is that there is a mechanism for a review court that EU citizens can go to. It's an independent data protection review court where the court would be composed of people chosen outside the U.S. government and who would have full authority to adjudicate the claim. So it is hoped that this will satisfy the concerns of the European Court in Schrems II and lead to a workable framework between the EU and the United States.
Thank you so much. I don't know, Megan, if you had anything, commentary there or on whether we need another internationally scoped treaty to get us further.
Yeah, I agree with what Vivian said, and I think that I find it very interesting that in watching this play out, that there are a lot of interests who very much want to, and a lot of corporate interest, a lot of government interest in figuring out a solution to this, and just keep running up against some serious problems with the way that the EU court has addressed this. So I think, you know, it's interesting to see all the resources that are being put to try to come up with a solution, and early reports that I have heard, just as you know, on the news and whatnot, is that it is the new framework is going to have some similar challenges as the prior ones, and we might have a Schrems III. Right. But it's you know, there's a lot of smart folks looking at how to solve this problem, but we'll see what happens.
Megan, I'll stick with you. Many jurisdictions have started to have new data localization measures, excuse me, and blocking statutes. Have U.S. courts started to interpret conflict issues differently?
Yeah, it's a great question. The paradigm has been the GDPR, and that's where the case law has evolved. And U.S. courts almost universally have rejected the interests protected by the GDPR in favor of U.S. federal civil rules of procedure. I think now that we have this explosion of data protection regimes in other jurisdictions, it's going to have to, the courts are going to have to reevaluate those original holdings. Because, for example, under the GDPR, there are some exceptions in which you can transfer this data. Some jurisdictions are, including China's recent regime, which I touched on, those restrictions are exceedingly small, and in some cases, just an outright prohibition. So I think that's a different analysis that the U.S. court is going to have to go through when faced with a data protection regime that does not allow for transfer for a legitimate interest, or that there are no exceptions. And so I think that we are really going to see an evolution in the case law as U.S. courts start evaluating how U.S. law and these foreign, when they truly conflict, and when there is an absolute conflict, as opposed to under the GDPR, where sometimes courts have found, like, well, you probably could find a way to do this if you really wanted to. But you know, so one recent test case we have is a district in New Jersey. A court in the District of New Jersey recently considered a request for discovery from under the new Chinese data protection law, and said to the parties, like, that they were not freed of their obligations under the federal rules to produce information from China, even though it conflicted with the Chinese data privacy law. So I think, again, it is just essential to educate courts on the difficulty that's at play here, and the real restrictions that the parties are under, and the extreme sanctions that could be imposed for violation of these data protection laws. But so far, we have not had particularly encouraging results.
Let's open it up to the audience. If anyone wants to ask a question to one of our experts, you can feel free to raise your hand. Please, if you'd stand, your name and affiliation, and then pose the question.
Thank you, that have simplified and made it possible to comply with the GDPR in doing discovery. And if you look at legislative proposals in places like Germany to allow for document discovery under the convention, and the practice in some countries now to qualify their objections to document discovery under the convention, I wonder whether there's a case to be made that says, actually, things are going really well, or are trending in the right direction. I just want to get your reaction to that.
So I am glad that you asked that question, because I do have to admit that in the last year or two, I have been starting to see in the French periodicals, which publish the articles about, well, that have been publishing the articles that I'm referring to, where there's a decrying of 1782, the beginnings of, hey guys, there's this weird mechanism out there that can really be great for our cases. But that, of course, is true if you represent a party in a transnational case and you happen to have documents, or if, as you say, both parties to the case can use it, then, of course, the lack of balance or inequities are mitigated greatly. So I cannot say that you're wrong. I wish I could, but there's something about this idea somehow that we in the United States are just intruding in the situation where we are giving information under our huge discovery setup that that is absolutely not available in the other country. And it's not to the tribunal, it's to the private party that that irks me. But on the other hand, what you're saying about the tribunals is also accurate.
We've just heard applause from another room, so obviously we're abutting time shortly. But any other questions? Speak now, or you may contact these lovely ladies after the fact via email. Anyone else? Okay, mindful of time then, if you would join me in congratulating our experts for joining us today. Thanks to all of you for joining us as well for what I believe is the last session of the day. But if I'm wrong, let's just check the schedule. Thank you so much, everyone.